Hello, lovely landlords. On 1 minute past midnight on the 1st of May, the Renters' Rights Act means that every single tenancy in England goes into breach. And the only way you can get that tenancy agreement out of breach is by first sending out the information leaflet. And you've got until the 31st of May. But if you think that sending out the renters' rights information sheet is simply attaching a PDF to an email, pressing send, I really need you to stop and think again. Because what looks like a really small job could become an expensive problem in the future. The only guidance that everyone's been given is it must be sent to every tenant. So this isn't about just pressing send, not because we're attaching a document. It's what happened is this has been made to look so simple. Now, if you never want to gain possession of your property, that's no problem. Because get this wrong, and the first thing you're going to be asked, if you issue a Ground 1 or Ground 1A because you want to sell or move in, is how this was done. Because it's actually a legal communication. It links to your tenancy agreement, your method of service, your covering letter, your evidence, your possession position, and your legal cover. And your risk if things are challenged later. So, are you a landlord? And you're asking yourself the question is, well, can I send the PDF? The real question is, do you know how to send it safely? Do you know what your contract says? Do you know whether the email is the right method? Do you know whether every named resident has actually received it? And do you know what evidence you need to keep? Do you know what your covering letter should say? And do you know what, just importantly, do you know what your covering letter must not say? Because one careless sentence could create confusion, weaken your position, or give someone an argument against you later. And that's where this becomes really risky. Let's be honest, most problems with property management don't start with someone deliberately doing something wrong. They actually start with someone thinking, looks quite straightforward, I'll just do it myself. And that's really exactly the danger here. The Renters' Rights Act is the biggest change to the private rented sector in 30 years. From the 1st of May, the way possession works changes totally. Section 21, no fault eviction ends, and owners will need to understand the new systems, the correct grounds, the correct notice, and the correct evidence and the correct process. So when people say, surely it's just sending the information sheet, my answer is no. It's going to be starting with sending the information sheet, but the risk sits with everything you do around it. So let's start with the first question. Are you assuming that sending a PDF by email is the right way to do it? Not sure? Well, what does your tenancy agreement say? Because before you decide how to serve anything, you need to know what your existing tenancy agreement allows you to do. Remember, this is a legal notice. Does it allow service by email? Okay. Does it require post? Does it set out a particular method, recorded delivery? Does it say something different from what you actually assumed? And if you've not checked that, how can you possibly know whether your covering letter is worded correctly? And this is where landlords can walk straight into a problem without realising it. They're not thinking about the tenancy agreement. They're not thinking about service, not thinking about the evidence needed. They're thinking, I've sent the PDF because that's what the government has said. Job done. Tick. But is it? So let's take another situation. Have you already got a Section 21 notice in play? Yes? So are you thinking, don't need to send the information sheet out because my tenants will leave at the end of the Section 21? you sure about that? Does it matter what notice is already running when the Renters' Rights Act comes into play on the 1st of May? Does it matter what you say in your covering letter if there is already notice in place? Do you know how to avoid creating confusion with the whole situation? One tenancy is in breach, another tenancy started. Do you know how to avoid saying something that could undermine the position that you've already taken? And if you're not 100% clear on the legal position of those questions, how are you expected to know that your covering letter is absolutely safe? The whole situation is not just about what you send. It's about what your words mean and what you want to do in the future. What are you saying in that email? Are you referring to a current notice? Are you referring to possession? Are you saying anything about the tenancy ending? Are you making it sound as though something has changed when actually it's not, because your original tenancy has notice in play? Are you accidentally giving your resident an argument later to stay at the property? And that's why the covering letter really matters. This is why people, in my mind, are underestimating the risk. They believe the task is the PDF. It's not. The task is knowing how to send the right information in the right way to the right people with the right wording, with the right evidence behind it. And if that sounds like work a professional who understands the legal position should be doing, well, that's because it is. Let's be honest, you don't pay a solicitor to send a letter. You pay them because they understand the law behind the letter that they will send. You pay them because they know what that letter needs to protect. You pay them because the wrong wording could cost you a lot of money later. And that's exactly the same principle. If your agent, for example, is doing a bulk email for free, fantastic. But are they actually protecting your position? Do they understand the minefield that's out there, that if in the future you want to gain possession, you've got to rely on that notice? So let's talk about legal cover, because I know some owners will be thinking, not too worried, I've got legal cover. And legal cover, believe you me, in this new world is really useful. But it's not going to be a magic shield for a poor process. And we all know that insurers do look for any reason not to pay out. So will your legal cover protect you if the information sheet was served the wrong way? Will it protect you if your tenancy agreement didn't allow you to use the method you used? Will it protect you if the covering letter said the wrong thing? Will it protect you if you can't prove that every named resident received the correct information? And will it protect you if your own wording weakened your position before you even realised there was a problem? Because by the time you need to rely on legal cover, which could be a couple of years down the line, the damage has already been done. You've got until the 31st of May to get this right. And that's the point. Good tenancy and property management is not about waiting until something goes wrong. It's about reducing the chance of something going wrong in the first place. And that's what professional lettings is all about and should be. Yes, it includes collecting the rent. Yes, it includes maintenance, and it includes dealing with the dripping tap. But that's the only part that you see. What you don't always see is the legal training, the scenario planning, the risk management, the record keeping, the compliance checks, and the constant work that goes on in the background to protect landlords. Over the last 2 days, for example, I've been working through the Renters' Rights Act, some scenarios with other lettings professionals. And believe me, this isn't theory. These are real situations that we believe landlords are going to face. For example, what happens if an owner wants to move back into a property? What happens if they want to sell that property? Can you rely on the grounds that you think if the property is owned in a company? What's the first tier tribunal going to be expecting to see? How will these new enforcement officers deal with complaints? And what happens if your resident challenges the position that you're holding? It all starts with the information sheet you send. Over the last 30 years, the meaning of the Housing Act 1988 has been set in case law. And that's exactly what's going to happen with the Renters' Rights Act. The main issue will arrive when you want to gain possession. Because if your tenants don't leave at the end of the term that you've served, you're going to go to court. And the first thing that a barrister is going to be looking at is how you ended the easy peasy information leaflet. How was it sent out? Get that wrong and it's going to be expensive and you're going to start again. What it means from case law point of view is that someone's paperwork is going to be picked apart. Someone's covering letter will be examined. Someone's method of service will be checked out. And you don't want to be the case that becomes the warning story for everyone else, where everyone's going, "Ooh, thought that was right to do." And that's why we as a company are being cautious. That's why we're being diligent. And that's why we're taking this really seriously. Because once this starts being challenged, the landlords who thought it was just admin may be the ones who find themselves in the most difficult situation. Now, let's be clear. This isn't about frightening landlords for the sake of it. It's about making sure that you understand the risk before you walk into it. You've got until the 31st of May because the minefield out there looks harmless. So what are we doing? We're checking the position. We're considering the tenancy. We're thinking about the method of service. We're thinking about who needs to receive it. We're thinking about the wording that goes with it. We're thinking about what must not be said. We're thinking about evidence for future. And we're thinking about what happens if possession is needed later. We're thinking about the questions. At Maxine Leicester, we've been studying the Renters' Rights Act since 2019. We've written about it on numerous occasions. We've trained the team on it. We've talked to landlords about it, several webinars. We've looked at the practical risks, and we've done that because our job is not to react when something's gone wrong. Our job is to help landlords avoid expensive mistakes in the first place. So if you're watching this and thinking, I was just going to go and send the PDF, please stop and ask yourself, do I know what my tenancy agreement says? Do I know how this needs to be served? Do I know what evidence I need? Do I know what my covering letter should say and what it must not say? Do I know what happens if I already have a Section 21 notice in play? Because this is not just sending a PDF. This is protecting your position. This is understanding the law behind the communication. And this is making sure that when the rules change, you are not left exposed. So yes, as a company, we charge for this service. And we're going to make no apologies for that. Because we would rather have a difficult conversation now than see a landlord face a much bigger problem later. So if you're a landlord and you're not really sure what the answer is to all these questions, you are walking into a minefield that, yeah, it looks harmless at the moment. So why not message us leaflet, and the Maxine Leicester team will help you get it right. We look forward to talking with you.